Good morning, good afternoon, good evening. Welcome to Digital June 2021. We are halfway into this conference. We had amazing 2 days with 4 sessions, 2 sessions each day. Day before yesterday, we started with opening remark and opening conversation and keynote about, looking at this, 35,000 view of Digital India, looked at different factors which are fueling and create catalysts to the growth of digital economy in India. Then we looked into how do you enter India, where we discuss M&A and other issues related to investment structures. Yesterday, we looked at regulatory issues in digital India, because those are the new technology, and new technology always creates unexpected regulatory issues, and we continue to see that. So we had a great discussion on that. We also talked about data protection, data sharing, data securing, data ownership, all those issues that we discussed yesterday. Today, we have another great 2 session. First session is on competition law, on antitrust, and we have amazing panel here with experience in this area. You may have heard about this, but in US, there has been a development. Yesterday, there was an announcement of the new FTC head, Ms. Lina Khan, or Dr. Lina Khan. I believe she has become the head of FTC, and she is very much into antitrust issues. So we expect antitrust to come up, especially for the digital economy companies. So we look forward to having that discussion. And now we move on to the panel today on antitrust. I would like to say that the session today focuses on preferential treatment and exclusivity on platforms, which is basically, digital economy companies. It's supported by Cuts International. The session chair for today's session is Mr. Nishith Desai. He is the leader of international dispute resolution and investigation practice at Nishith Desai. And with him, we have 4 experts. Dr. Payal Malik, she's advisor and head of economics division at Competition Commission of India, CCI, which is the regulator in India. Ms. Payal Chatterjee, she's the leader of international dispute practice at Nishith Desai Associates. Mr. Suman Berry, he is the global fellow at Wilson Center. Also, he was on Prime Minister's advisory committee. And Mr. Vinay Shukla, he is the leader of corporate and competition law practice at Nishith Desai Associates. Now, during this panel, given that we have so many attendees, we have put all the attendees on mute, so you will not be able to verbally ask questions, although we would have loved that. It just creates too much chaos. So what I suggest that you put your questions in chat, and session chair will look at those questions, continuously moderate them, and pick them up in their discussion with the panel as they see appropriate and the time permits. However, after this panel discussion is over, we have a special breakout rooms for each speaker, which you can join to meet the speaker and the greet speaker and converse with speaker, kind of like in a real conference you meet on the sideline. So with that, I will just give 2 last comments. One is the disclaimer. Obviously, these people come from a very reputed organization, all of them. However, they come in their personal capacity. The views and opinions they have presented here are their personal views at this given point of time, but they are not necessarily of the organization at which they work. Also, I want to take this opportunity to thank many prestigious organizations who have supported Digital June 2021, Center for Digital Future, Cuts International, FICCI, IAMAI, IFA, IBCA, NASCOM, Thai Silicon Valley, US India Business Council, and the Wilson Center. In addition, we also have Rand Capital International, which is strategic investment arm of the Times Group as a media partner. So thank you. Welcome to Digital June. And without any further delay, I would like to hand over to Vyapak Desai to take on the entire session. Thank you.
Thank you, Mihrbhai, for this introduction. And without much ado, I'll straight away get into the topic. Now, everyone possibly on this call has a bit of understanding on what topic that we are, trying to debate and discuss today. Competition law as a subject has evolved over maybe last 2 decades. Earlier, when we talked about competition law, it was all about cartels, it was all about brick and mortar companies, it was all about cement cartels and competition issues around it. It was about the automobile sector. It was all about the other sectors which continued to grow and control the economy in that era. With the digital economy, with the advent and the growth of platforms and marketplaces, I think competition law as a subject has completely changed. What was considered to be a competition or anti-competitive then, maybe not now, considering what some of these platforms provide in terms of consumer benefits at one end, while at the other end, what goes behind the scenes may be anti-competitive for other B2B channels. So the whole landscape has changed, if I may say, overnight in the context of the economic developments. While it has taken obviously a few years, and we have been seeing, even in India, we have seen the marketplace study and some of the judgments for last 2 to 3 years, the growth of platforms like Google at one end, while other platforms like Amazon and Flipkart and consumer portals like Make My Trip and the auto portals like Uber and others. So there has been a huge change in the landscape. The biggest 2 issues that Competition Commission and the players in this economy are dealing with is possibly the preferential treatment and exclusivity. Obviously, preferential treatment comes in many different phases and many different structures. Earlier, again, if I may just use the analogy of brick and mortar situations, where we had large chain of marketplaces, physical, even at that point in time, how the products and how the sellers were having some kind of a preference in a particular marketplace versus another was some kind of a concern. But still, it was something you can see, feel, touch, and analyze. Today, with the kind of backend, there is a huge enigma around what is happening in the background. Is deep discounts good for consumers in a short term, but what happens in the long term? Are the preferential treatment and exclusivity arrangements around this platforms good or bad for one stakeholder versus the other? How do Competition Commission in India and elsewhere looks at it? How the conflict of interest, where some of these platforms play a dual role. Sometimes they do have their own private labels, they have their own products on the platforms, while they also deal with third-party vendors on their platforms. So how do that conflict of interest work in the scenario of platforms? And there are hundreds of permutation combinations around it. So with all that complications and confusions, to discuss this, we have very 2 eminent external speakers and very 2 people from NDA, Vinay Shukla and Payal Chatterjee, to talk about some of the Indian developments as well. So with that background, let me go to Payal Malik straight away and understand some of these issues from her, and to put it straight, right? Payal, from your perspective, how has national regulator CCI been looking at these issues, right? They are grappling with these aspects. What have been the challenges faced by them in assessing anti-competitive conducts of the digital platforms? You are on mute, Payal.
Yeah, can you hear me? Yeah. So
Yeah,
thank you so
perfect.
much. Yeah, thank you so much for laying the ground. And I actually, you filtered the topic very well, because the title of this particular session is Preferential Treatment and Exclusivity Arrangements. And those two conducts precisely are being looked at by competition authorities worldwide and not just in India. So the reason why this has become so central to antitrust interventions and antitrust investigation is to basically, as you had said in your opening remarks, these online marketplaces, which are, and in the Indian context, I would like to give you the Indian context here, are the main access routes for sellers and retailers to reach online consumers. Just to give you some numbers, in India, around 64% of online sales takes place through these marketplaces. So we are defining a distinct market here, that is an online marketplace, and we are not seeing substitutability now between the bricks and mortar, because gone are the days when there was online marketplaces were just distribution channel. The rest is through the large brands web shops. So for small retailers or small brands, it is an impossible proposition to open a website and attract consumers' traffic. So their dependence on marketplace platforms is therefore tremendous. The search and comparison functionalities of the platforms, the network effects that work in their favor, lead to huge consumer footfalls on these platforms, and therefore the criticality of these platforms for sellers is indisputable. And as you pointed out, there is these platforms being two-sided markets. There is the consumer side and there is the supplier side. Now, the consumer are seeing humongous amounts of benefits. Of course, with disintermediation comes benefits. With scale come consumer benefits. So demand side efficiencies are, in that sense, undisputed. So that exactly is the dilemma which antitrust authorities face, that given that there are so many demand side efficiencies, wherein lies the problem? The problem is, as in my opening remarks, I've given you the criticality of these platforms for vendors, basically, to reach and access their customers. The relationship between the platform and the supply side of the market becomes very important. The supply side of the market being very, very fragmented, so the bargaining power is less. Whereas in certain platforms, in fact, the supply side of the market, the bargaining power has increased because of the coalitions they have formed. For example, is the food and the restaurant platforms. So these kind of preferential treatments, and this was looked into by the Competition Commission of India in a very recent case, which went through lots of legal hooplas, and finally, just a few days ago, that is last Friday, the Karnataka High Court lifted the stay on investigation into the issues of preferential treatment. So let me talk about this preferential treatment and what was the allegation. So certain popular smartphone brands launched their new models exclusively on either of the two large marketplace platforms, and they are allegedly sold primarily through a handful of sellers on these platforms. Even if other retailers were to get access to these products, they would not be able to compete effectively with the handful of sellers who make these products available at deep discounts and get a better search ranking on marketplace platforms' website. So this is just the bare bones of the case. So neither exclusivity on its own is bad, nor under the competition law, given the analytical framework, because these preferential relationship between the platform and certain preferred sellers is not per se anti-competitive. So it is looked through a rule of reason framework. But the prima facie opinion which came out of this case basically was that it is exclusive launches, and especially in smartphones market, exclusive launches of certain smartphones sold to a certain set of preferred sellers, prejudice to the other sellers in the market, and also funded by perhaps the platforms. So again, this is a matter for investigation through deep discounting. Now, as mentioned, disintermediation, scale economies, efficiencies, etc., are not frowned upon by antitrust law. So if there are benefits to the consumers on account of these three aspects which I'm talking about, there should be no problem. But the issue at hand is that, is this ecosystem where a few preferred sellers get an advantage over the other sellers on this marketplace, and also through a discounting mechanism which supports only these preferred sellers, is this conduct competition on the merits? So in digital markets, as we know, due to network effects, the endogenous market structure is such that a few platforms, given the demand side efficiencies, only a few platforms will exist. But if the network effects are coupled with a slight bit of anti-competitive conduct, this just tilts competition in the favor of few. And that competition, whether or not it is a competition on the merits, is an issue. The other aspect, and that's I will just end with that aspect when it comes to preferential treatment, when we are looking at preferential treatment, is again, exclusive launch per se is not an issue. But if the contours of such deal are such that they benefit the parties to the deal and harm competition on the merits in digital commerce, they will cause irreparable injury to the prospects of a broad-based digital India. What are the other forms of preferential treatments which also came forth in some of the investigations? Because the topic is very, very narrow. So I am limiting myself to online e-commerce platforms when I'm talking about preferential treatments. That there could be some, even if there is no ownership nexus between the platform and the preferred sellers, there could be some tacit understanding between the seller and the marketplace. So it could result in some tacit exclusive agreements where the sellers agree to sell exclusively. That's one part. But preferential treatment may also arise if the seller agrees to pay higher commission in return of better exposure on the website. So this is the algorithmic issue. It is also possible that marketplace, since it is not able to sell its product directly, may favor those sellers who are selling its private label products in search results. This way, the marketplace not only just prioritizes its own products, but also the seller. So that's the nub of the problem. And so we will, going ahead, I'll be happy to take more questions. But the underlying reason that the competition authorities are looking at this is whether or not the competitive process is maintained. And it is not about protection of the small players on the platform. So scale efficiencies are well regarded for and well accounted for in the analytical framework of antitrust law. But the underlying motivation of looking at these cases is to see whether the competition is on merits. So I will end this section of mine on
Sure.
these points.
No, I think that was very, very relevant and possibly gives an excellent overview of where India stands today in a possibly shortest possible time. So I think this was very, very helpful. But I think while the biggest question which generally we face as in life is to be or not to be, right? But when it comes to Indian regulators, the biggest question is how much they should regulate and how much they should give a free hand. Because while the businesses and economies are in a way becoming fungible. Earlier, what happened in India may be very different in US, very different in UK, very different in other parts of the world, because they were very different businesses, very different way of doing businesses. But when it comes to digital economy, when it comes to marketplaces, I think some of these issues are very common across many other jurisdictions, and therefore it's not that we can not learn from each other when it comes to different jurisdictions. So if I may bring Suman Berry here, why you have a very focused eye on India, but you also understand many other jurisdictions and many other markets. So you very well know what's happening in India, what Indian regulators are looking at this point in time, and what other jurisdictions are doing. Is there any trend that you are seeing? Is there any learnings both ways as to how other jurisdictions are working, how India is working, and how each other can learn from here? And what's your take as to what India should do from here on?
Vyapak Bhai, thank you very much, and I appreciate the invitation, because I'm not a domain specialist. I'm a development economist. I did head NCAR and then was the chief economist of Shell. I'm speaking now freely, although as a global fellow of the Wilson Center, which is one of your sponsors. But I also have a relationship with a think tank in Europe called Bruegel. I'm a non-resident fellow there. And so my response to your question, and you've teed it up, is really what are the right lessons? What are the wrong lessons? And I will be particularly, focusing on what I picked up about these issues in the EU context, because we have a continuing discussion of this at various kind of Bruegel meetings. So, I think, Payal and I work together at NCAR. Even while she has a narrow remit and has to be careful about what she says, we are really talking about how the legislative framework and the regulatory framework and the enforcement framework are appropriate for a developing economy, okay? And a developing economy which has been quite successful at integrating itself into the global digital ecosystem. So I'm going to come back to this, because I do think that, as the legislators, as the regulators look ahead, they need to be mindful of the fact that we are not only talking about effects in the local market, but possibly effects in the global market. And let me just say up front, because there have been, some murmurs to the contrary, that there is no case for, as it were, economic nationalism in this area. So the rules that are established ought to be rules that apply to all comers. Okay. Now, let me just talk a little bit about what is happening, particularly in the EU, but I think the point that Mihir Bhai made about Lina Khan is pertinent to this. And then we come to, as it were, what the implications might or might not be for India. So, as you know, not unlike what's going on in India, Europe is also contemplating a Digital Markets Act. And the question is, why is it that we are moving from case-by-case competition enforcement to the need for legislation, which would then be the foundation for regulation? And I think the answer to that, Vyapak Bhai, is that from a sense that a decade ago, competition was working. Alta Vista was replaced by Google, Microsoft, IBM is no longer the power it used to be. There was certainly a US doctrine that, look, let well enough alone, competition will work. But I think some of the arguments that Payal has put forward and which are available on the Bruegel website have shown that there is tipping point behavior which entrenches the power of the platforms. And then once their power is entrenched, they have the capacity to, as it were, influence or they have a dominant position in the two-sided market. And so people are beginning in Europe and the United States to argue that, look, you have to have ex ante restrictions on these companies. Case by case enforcement is going to be too slow. Okay, so this session is about the role of competition. I'm saying in other markets, the focus is now about, as it were, curbing these these dominant companies. And I think the discussion should be, is that in fact necessary globally? I think the question for this forum is, can we let the big boys handle that, or do we need any equivalent of that in the Indian space, or don't we? I don't have a firm answer to that, but I would have thought that these larger global issues, including the taxation issues, could well be sorted out at the level of the mature markets. Now let me just come to what I think of, and then I'll stop there, of what are the things that matter for a developing country. And I think I've already indicated that nationalism is not one of them. But I think the real question, including for the rich countries, but here I'm talking about India, is, how does the ecosystem stimulate innovation? Okay, and I don't know whether that is an element in the consultations of the government on the legislation. I don't know whether that is an element in the judgments of the CCI. But what I would say is three things, and I'll close here. One is that India is and has been for 20 years a successful exporter of IT-enabled services. Okay, and we don't want to throw the baby out with the bathwater, even as we test the temperature of the bathwater. Secondly, because we haven't got our act together, we are shying away from, digital protocols in the WTO. We have not wanted to be part of the plurilateral. There is a work stream at the G20 on digital that Japan launched. And again, our attitude is, don't confuse us with all of this, whereas I think we must embrace this, because ultimately, the last 20 years have shown that our comparative advantage is in services and not in manufacturing trade. And so we do have to be extremely mindful of how the regulatory structure that we put in place is inviting and, actually makes us a preferred alternative to China, rather than, as it were, creating a walled garden, which is imitating in some respects what's going on in China. I've spoken too long, but I just thought I'd add these additional perspectives, which are somewhat outside the scope of the session, but may still be of interest to your audience.
Yes. No, that's very, very relevant. In fact, I'll come back to you on some of these aspects shortly after, discussing one or two other important points and bringing to the attention of the audience. And coming back to Payal Malik here, and at one end, of course, what all we discussed is the, in a way, dominant positions that these marketplaces put themselves in. But one of the real driver for they becoming that dominant, right, or able to use aspects of preferential treatment or exclusivity in a sense, is also the power of data, right? At one end, I think that's another aspect altogether. And I don't know how much of that is relevant for the perspective of our discussion, but I want your thoughts on it, that at one end, there is a huge amount of legislation and discussions around data privacy. On the other hand, this marketplaces and online platforms do collect and have the advantage of data collection of the users over a period of time. Now, this can be also aggravated with different marketplaces and different kinds of data collection under one umbrella, and we can talk about those companies separately without naming them. But that can also be the entry barrier for other players to enter, and therefore can be anti-competitive in that sense. So how does all this culminate into the aspect of competition? Are these entry barriers relevant? Are there anything else, or are the regulators looking at this as one of the factors and seeing what can be done to ensure there are less entry barriers and therefore better competition, and these issues are addressed on its own rather than regulators coming into forefront? So again, if you have any particular views on this aspect.
To myself, thanks, Vyapak. You have introduced now, opened another, as they say,
can of worms.
Warfront. Yeah, Warfront. So data means all those who are looking at digital platforms, data is key, and so that's extremely important. And so herein lies the problem. It is the ability of these firms. So they bring in huge, great technology. And so that need not means no one is questioning that. So the technology which came through these platforms, the ability of these platforms to refine data, use data to the service of consumers is undisputable. So if we agree on this, now where does the problem lie when it comes to data power? So as I had mentioned earlier, that it's a self-fulfilling prophecy. It can be a virtuous circle for the companies, but it may be a vicious circle for more entry, for competition, and in the dynamic sense, even for innovation. So let me first answer, take some cues from what Suman said. The relationship of these platforms with the other aspects of our digital economy, that is the startups and the other small businesses, etc., can be a synergetic relationship. So the aim of all regulation, be it an ex-ante regulation through say a specific policy instrument, be it in the e-commerce market space or through other policy instruments in the social networking market space, the aim of all regulation should be to get this synergy working. In some sense, these platforms have gained what is known as an infrastructure status. And general purpose, so they have become what is known as general purpose technologies. And when they have got an infrastructure status, so therefore a mix of instruments, absolutely, and antitrust is central to that instruments, needs to be applied in order to regulate that ecosystem, to get it to a benefit to both the supply side of the market, that and the users, not the end users, but the intermediary users, which would be the customers, be the startups, be it the small producers, etc. And so that becomes crucial. Now coming to quickly to your question of data. So once the data, so as I said, it becomes a self-fulfilling prophecy. A large platform gathers more data, due to the cross-site network effects, more consumers go on that platform, which are more suppliers, and this just creates mountains and mountains of data for the platforms to use it for providing new products. Not only that, this data has allowed these platforms to mutate into different verticals and mutate into different markets. So who could have thought a few years, 10, 15 years ago, a search engine could get into, say, driverless cars. So this mutation into various markets has spurned has started what is a virtuous circle of innovations. Absolutely. But from the competition perspective, the lens now, which is being used increasingly, is it good that the data should be in the warehouses of only a few selected firms? Or democratization of data is essential for not only for a competition perspective, but for other outcomes in an economy or a society. So the concentration of data, and of course competition law is very, very much equipped to look at data concentration as in defining dominance. Our frameworks are there in order to see this aspect. The concentration of data is now creating problems. Now, what are these problems and how our competition authorities are looking at it? So the way the data is collected, though that happens to be now in the domain, so these boundaries are blurring, whether or not there is a domain of a data protection authority, where does the domain of data protection authority stop, where does the domain and the end of an antitrust authority begin. So there are no distinct lines to say that there is an ex ante and an ex post. In fact, even competition law has ex ante instruments in the form of merger regulations. So merger and acquisitions can be a very, very important point at looking at data and data sets being integrated on account of acquisitions. So whether these data sets, whether this acquisition, by and large, acquisitions are driven by integrating data sets and creating more data power for a given company. So that instrument is also available. So my point here is that it has to be a harmonious integration of various regulatory instruments when it comes to data. Recently, the Competition Commission of India looked at data power from the lens, not from the lens of privacy, which is a consumer protection issue, but the privacy rules leading to collection of data, which is over and above, which is required for the purpose of the business at hand. All right, which gives undue power and entrenches the market power of an already dominant entity. Is that good for competition? Because it allows that particular dominant entity to leverage into various other businesses and cement its dominance in those markets. So not only is the given product market, which is under threat when it comes to competition because of this data power, other markets gets foreclosed. So so when we are looking at platforms, we have to understand the definition of a platform. The definition of a platform is precisely this, of building blocks. So a platform which is as an intermediary and an infrastructure facility uses, and precisely that on account of its market power, uses that data which is available on a particular platform to build blocks and enter into various markets. So the ecosystem, it's more like an ecosystem competition than a product market competition. And that's where the importance of data and data power comes. And so what are the solutions? So solutions are, as I said, various instrumentalities. There would be certain data protection laws which would be looking at privacy, and hence looking at the privacy aspect, and hence also giving some power back to the consumer when it comes to their own data. So the data protection law talks about data principle and data fiduciary. Then there can be antitrust instruments. Then there are other instruments of talking about interoperability between platforms, data sharing by a dominant platform as an antitrust remedy. This Competition Commission has used that in one old case in Bayer Monsanto, where Monsanto as a digital platform having access to agricultural data was asked to share that data with government entities in order for research and development. So where does the innovation theory of harm jump in? The innovation theory of harm jumps in when this data is just concentrated with one or two companies, then the other companies who need that data in order to develop and innovate would require some access.
Sure. No, I think that's very, very relevant. And again, it's a topic by itself. While it is relevant for the purposes of the effect on the issues at hand. But in my view, that's another larger topic which requires attention, and I'm sure all the governments, including the Indian regulators, are grappling with this aspect. But let's bring in the other Payal here, Payal Chatterjee, who heads and leads our competition law practice along with Vinay Shukla. Both are part of Nishith Desai Associates. While we have heard Payal Malik and Suman on some of the macro level issues, some of the aspects which are relevant at the point in time and how it should be looked at in the future. But to bring in little more context for at least audience and people like me who may not have full understanding of this larger topic, we do have some guidance, some jurisprudence, some direction as to how things are moving in the minds of courts and the people who are going to ultimately look at regulator at one end and the businesses at the other hand, which are the courts, which bring in sanity in some sense. So we have Google judgment, we have Amazon judgment. So maybe Payal Chatterjee and Vinay Shukla, if you can come in, but very quickly give some context to this whole discussion so people understand, and then maybe we'll again shift back our focus to Payal Malik and Suman on the aspects of self-regulation and the current market study which CCI did, and how will that shape up as we go along.
Thank you, Vyapak. I think after hearing Payal and Suman, I'm not sure how much value add is going to come from our end, but so we are going to restrict it as purely as antitrust lawyers, looking at certain rulings which have come up in the last few years from the CCI and understanding and analyzing those, how they have looked at those issues and giving a more of a outsider's perspective as to when we have read those judgments, what have been our takeaways from those rulings. So I think it started off when the first ruling which we are going to discuss today is obviously one of the biggest digital giants, Google. Now, Google, as we all know, is facing a lot of heat when it comes to various regulators and various jurisdictions across the world. So India is no exception. One interesting aspect which we have seen in this Google decisions when it comes to Indian territory is it's not just the Indian entity of Google who has been made a party, but we have seen the Google LLC as well as Google Ireland, as well as the two Google India entities who have also been made a party to these proceedings. As Payal already mentioned in one of her topics, that when we are talking about preferential treatment, exclusivity, some of the issues which come across is how is the algorithmic aspects being handled. Now that's one aspect which was dealt with in the Google decision itself. Now, Google has had multiple proceedings in India, starting from the 2018 decision, where CCI had imposed a $20 million penalty itself on the ground of them having abused their dominant position in the relevant market. I'll come back to what the market was for that particular case. And then again, going on to saying that they have again been in a dominant position and abused it when it comes to the OS, the operating system market itself, and thereby actually compelling the smartphone manufacturers to have to abide by that particular OS. Then also at the same time mandatory asking them that you have to go by the Google Play Store as well as give preference to the Google Pay, which is the UPI wallet which is available through Google. Now, moving back to the first decision in 2018, as I mentioned, there has been a penalty which has been imposed. But interestingly, as it stands today, the decision was appealed. There has been a stay on that CCI decision, and the matter is currently pending before the appellate tribunal. Now, what were the two main issues which that particular ruling dealt with? They decided, I think the first aspect was understanding what is the relevant market. There were two aspects to it. There is a general web search services itself, and the second aspect to it is the advertising services. CCI very categorically mentioned that these two markets are complementary, but at the same time, they are distinct markets in itself. And they went on to say that when you look at general web search services, that's distinct from a special web search services also. because there you have a specific URL. You go directly to that particular service and that particular website. And there are differences when it comes to the users, when it comes to cost, convenience. And they again differentiated it when it came to online as well as offline advertising services. What they moved on to say is there a way that Google is placing their own products or their own services in a manner that they get priority irrespective of whether the fact they are relevant or not? So in their search engine protocol, whether they are coming or appearing in the first few clicks itself as compared to their competitors. CCI went on to analyze and said that yes, there were three mechanisms, I would say, where they categorized and decided whether there is a search bias which is existing or not. One of them was the fact that whether there is a universal result system, there is a one box, and commercial unit itself. It's not that the CCI went with the complete DG report and agreed on all counts. They actually differentiated. And I think one of the interesting aspects which the regulator over here did is you just cannot have a one-size-fits-all approach when you deal with the digital economy itself. You need to have a very calibrated approach and intervene only to the extent it is required, and it needs to be proportioned so that you're balancing the competing interest as well as at the same time balancing the consumer interest as well. So CCI in this decision carefully held the fact that yes, initially when it came to the universal set, there was a fixed positions which was there, and yet the results did not come out as per the relevance. But that was something which was there till 2010. Google argued the fact that there was a lack of technology, and now they have corrected the fact. However, CCI held that this entire approach of having fixed position is unfair and discriminatory because it leads to denial of access, it leads to foreclosure as well as entry barriers. Whereas, I mean, while at the same time, we do have a dissenting view which said once it's already corrected by Google, whether there was a need to go that far as well.
Sure.
The next aspect was in relation to the advertising services, which held that they was giving enough information which was already being given to the vendors as well as to the other suppliers and intermediaries. So there has not been any such kind of breach. The last point which I wanted to deal before we move on to the other set of decisions itself is the Google's last decision, which has come in 2020, where we are talking again about the abuse of the dominant position, specifically with respect to the mandatory use of their Play Store when you do the in-app purchases, as well as the requirement to go for with Google Pay itself as the preferred or the preferential, I would say, the UPI wallet system. And obviously, we still have a prima facie decision there. There has been there's been a direction that there needs to be a detailed investigation which needs to take place to understand whether there is enough sufficient data to understand whether there are biases. Because is it that the operating systems which are there are not favorable? So the users would go ahead with a user-friendly click mechanism which easily shows you to GPay and not have to change the interface and go to another UPI wallet. I think that's yet to be seen. And CCI very categorically mentioned that one or two screenshots is not enough for you to determine that there has been a bias. So I think CCI is looking at the right direction. And I think Payal will throw more light as we move on as to how they are actually deep diving and analyzing these issues.
Sure. I don't know how much that would be divulged today, but at least we'll know some direction and at least the thought process rather than based on any factual information. And maybe Vinay, if you can talk about the Amazon Flipkart order, but again, very quickly, considering we also want to hear, Suman and Payal Malik again on a couple of points.
Yeah, thanks for that, Vyapak. I'm going to keep it short, and I think thanks, Payal, for the information dense, session. See, I think the way I look at it is that in the last 7 years, right from when the Mohit Manglani decision, was rendered by the CCI, what has changed? In the Mohit Manglani decision, the CCI sort of held that there is no difference between the offline and online markets. And actually, they're highly substitutable and that it's actually good for the economy. Now that is 2014, right? come to the last couple of years, 2020, 2019, right, where the CCI has actually held that, online e-commerce marketplaces and the services rendered by these e-commerce marketplaces are a separate relevant market, and that they need to be investigated, right? So what has actually changed in these 7 years? The answer to that is twofold, right? One is obviously the market realities have changed. Back in 2014, 2015, the times of Mohit Manglani and Ashish Ahuja, those judgments, the market was still nascent. There were a lot of players who were entering the market, because of which the CCI held that there are no entry barriers to the market and it is at a nascent stage. So dominance or anti-competitive conduct in that sense need not be discussed or evaluated at this stage, right? Now, in the last couple of years, the approach seems to have changed. They are looking at it from a far more holistic perspective. They obviously Payal ma'am's also there on the panel and she will elaborate, but it is no longer that an act is looked at in isolation, right? There is an entire ecosystem at play, and that ecosystem is evaluated by the CCI. So all these steps, right, preferential listing or deep discounting or exclusive arrangements, are somehow CCI is looking at it as being interconnected, and the entire ecosystem is what is going to be investigated, at least in the last few cases, that we have seen. Vyapak, do we have time to delve into those cases, or do you want to take it forward? Because those cases, I can go into the details of those cases, but I just want to know from you.
Yeah, maybe we'll come back to you if there's some time left, because we are maybe 7-8 minutes into the end of the session, and then maybe we'll see how things work out. But coming back to Suman Berry and Payal Malik, and I think some of these topics, unlike other regulators in India where there is absolutely no clarity what regulators are thinking, there is no guidance from the regulator. At least there was a market study on e-commerce platforms. Issues were particularly put on paper, while there were not many specific suggestions otherwise, but there was some indications on self-regulations as well. Do you think this economy and this kind of businesses are best suited for self-regulation? Do you think India should go in that direction? Do you think that is, compared to other jurisdictions, that is the way to go, considering the challenges Indian regulators and the businesses face in terms of regulating and monitoring the regulations in a way? Or do you think there is any other aspect that this can be dealt with? Maybe I'll first go with Suman, you, and then Payal can touch upon the cases and also the aspect that self-regulations. Yeah.
Just 2 quick points. One is I did have a chance to look at the e-commerce study that you put on your reading list, and it is impressive how important this was for MSMEs even before COVID. So I think the regulators have to have the equivalent of the medical Hippocratic oath: first, do no harm. Okay, so let's be clear about the unintended consequences. And secondly, the world over, certainly the US where I'm sitting right now, regulation produces regulatory capture. And so who is going to be the instrument of regulatory capture? The large firms. So my quick reaction to you, because I need to hear from Payal as well, she's the expert, is what is broke before you try and fix it? I'll stop there.
Yeah, I think that's a right possibly pause for Payal Malik to come in.
So what is broke before we fix it? So let me also clarify the 2 instruments which a competition authority has. And regarding capture, a market regulator, which is a multi-sector regulator, has lesser tendencies to be captured than a pure sectoral regulator. So those are the differences, because the market regulator is looking at various sectors. It's not just, we are not just dealing with the digital economy. So the two limbs of the competition law, which actually the lawyers forget one limb totally, and that is the limb of advocacy. So there was in 2018, and as mentioned by one of your colleagues, we started with looking at these digital platforms only as one channel for distribution, and so the offline-online distinction was not made. But those were early days. We are talking about 2014. But as soon means these e-commerce platforms started gaining traction, people started transacting on these e-commerce platforms. And let us not go by the percentage of Indian retail on e-commerce to basically say that it being negligible, there is no problem. So the issue was that as a competition authority, the commission then wanted to look at how the parameters of competition analysis, what regulations, whether it should be case by case, or there are certain behavior or practices which need to be there should be a persuasive element in the form of self-regulation. So as a competition authority, the commission wanted to make this debate less abstract and driven more by practical insights. And hence we had the market study. So there were concerns which were identified, and lack of platform neutrality was one. We're talking about preferential treatment. So we heard that business users had raised concerns about the neutrality of the platform, because the platform was acting as a competitor on the marketplace. And when the platforms engage in manipulation of search results, seller services, data and user review mechanisms, basically they lose all the agency. So it was a question of agency. So if you're a seller on the platform, the agency is stripped out of you because the platform acts as the regulator. Sure. And the second part which was happening, which we discussed when we were talking about preferential treatment here also, and then bringing in the data aspect of it, is the products which were best selling or for a particular vendor on a platform, that very product within a few months, and that these are cases are well known, within a few months come under the private label of the platform, because the platform is then able to sculpt the preferences of consumers on the basis of the data and come out with private labels to the detriment of the product, which was initially put forward by some vendors. So the Competition Authority went nimble, and still the Competition Authority's objective is to be nimble. So it went in through the route of developing a certain self-regulatory possibilities to improve transparency over certain areas of platforms functioning, such as search ranking, collection, use and share of data, user review mechanisms, etc. So both tools can be used, that is advocacy as well as enforcement. A case enforcement requires delving into a lot of evidence, going through the legal process, etc. Advocacy, if that communication goes through to the companies, can be also a very important tool. So just to give you an example of what happened post this e-commerce study, there were this exclusivity, certain phone companies, so certain manufacturing companies, for instance, Samsung, etc., they got out of these exclusive arrangements. So understanding markets, engaging with market participants, using the enforcement route, using the merger route, all routes have to be used. The end game has to be to develop a win-win situation for all sides of the markets and all participants concerned.
Sure. No, I get the point, and thanks a lot for that clarification. Maybe before I hand it over to Mihir Bhai for concluding remarks, Suman, do you have any closing points on this? We will obviously continue some of these discussions in the breakout sessions, and my suggestion to the participants is we can possibly join, most of us can join either Payal Malik or Suman Berry, so we can move between those two breakout sessions mainly to get their advantage. There is one question I see from Harish Jani on blockchain tech and the discussion paper which was published by Competition Commission. We'll try and address it in one of the breakout session as well. But with that short point, Suman, if you have any final
just
closing points.
I just have to applaud how far the CCI has come. When you consider the decade that it took to get the legislation in place. I mean, I came to NCAR in 2002, and I think the bill was already there, and there was the issue about. So just to go from there to the maturity of the e-commerce paper, I think we as Indians need to, because there's so much negativism, to applaud the institutional development that has taken place, including a firm like yours. So I just wanted to say that the quality of this conference, of the discussion, and of the issues being raised makes me very optimistic about India, and I appreciate being part of it. Thank you.
Yeah, thank you. Thank you. So over to you, Mirbhai, and we'll invite, there are a couple of questions I see from Aditya Raj and Harish Jani. We'll take it in the breakout session. But Mirbhai, your final comments, and then we'll go into the breakout sessions. Thank you.
Definitely, Vyapak, and this was an amazing session. Antitrust, I also enjoy reading about it because it directly deals with competitive behavior. And my background as a technology strategist, I enjoy that how companies use technology and business innovation to create competitive advantage. And that's exactly where antitrust fits in. And with the new technology, it gets even tougher, and new business model, which we have never seen, which spanning the boundaries of industry, which traditionally defined, and the market definition, as we were talking about it earlier, is that how those shifting market definition affect the regulators in dealing and taking actions. So this is very fascinating discussion. I want to thank you, Vyapak, for taking this panel through the very interesting journey. Also, I want to thank the experts, Payal Malik, Suman Berry, Payal Chatterjee, and Vinay Shukla. Wish we had more time, but time is short, so I want to thank you. What I want to also suggest is that we have applied for CLE, MCLE credit with State Bar of California and New York, and you can, if you would like to receive this credit, MCLE, CLE credit, then please write to linethh@nishithdesai.com and mention this code, because this code is important as a proof to show that you attended this session. The code is 91214. Again, 91214. Now, after this session, we have a next session, which is again another interesting session looking at equalization levy and tax consideration. And in 15 minutes, we'll be starting this session. But before that, you can certainly go meet speakers of this session in a breakout room. For the next session, please return to virtual lobby and refresh your page so the cache gets wiped out and you can join the next session. So again, thank you, the panelists, the experts of antitrust and competition law, as well as broader policy issues related with that. I appreciate you joining the panel and giving us the word of wisdom. Again, I thank everybody in the audience to join. And of course, I thank my digital June to make this entire session and the conference possible. So thank you, and see you all again soon.